Are you thinking about selling a business? Well, you need to know how different a business sale can be from a real estate transaction. That's right, when a business sale is involved and there's no real estate that's being purchased or sold, a business sale is completely different from a real estate transaction. We don't use the same contracts, we don't use a title company, and these types of transactions are typically handled by real estate attorneys. A business transaction starts with a letter of intent. A letter of intent is the intent to purchase or sell the business to an individual and includes the general terms of what's involved in the sale. It'll talk about what inventory and equipment's involved. It'll talk about, is a non-compete going to be included? Is the seller going to stay on for training? And it'll define the general terms and conditions of that business sale by giving the purchase price and the deposit and the closing date. You want to start with a letter of intent, but you want to make sure your letter of intent is intentionally written. In Florida, some letter of intents are construed to be a binding contract, unless you have specific language that makes it not to be a binding contract. It's so important, it's so critical to have a real estate attorney on your side when you're venturing for a business purchase and business sale. So many times that we're involved or we become involved after the fact, after a contract is signed by the parties. But the fact of the matter is, these contracts can't be the same real estate contracts that are used in a commercial transaction. They don't contemplate the same information. There's no title search, there's no title insurance. The terms are completely different from a real estate deal, so it's important that you understand the differences, so when you go to negotiate for the purchase price, you understand and you know what actually you're negotiating for. Do you want the seller to stay on and actually train you as a buyer for a time period? Is the seller going to be compensated? What times will the seller be available? What's the scope of that training? These are all conversations that you should have before the letter of intent is actually sent, so you understand what exactly you're selling and what exactly you're purchasing. Some transactions might not even involve the name of the business. The name of the business is what we call the trademark name, and in some transactions, the trademark name is not even included. Is the trademark important to you as a buyer? As a seller, do you want to keep that trademark name and not transfer it to the buyer? It's so important that you make sure that these items are negotiated before you sign the letter of intent, and especially before you sign that asset purchase agreement. Because before you sign these documents, that's the time to negotiate, that's the time to be clear what's included, and that's the time to protect yourself. So if you want to protect yourself, you need a knowledgeable real estate attorney helping you navigate through this complex process.